Palestinians are not part of this. They not only should be part, they should be the controlling feature because they are able to govern themselves.
Does Trump's plan provide a pathway for ending the genocide? Or is it essentially a continuation of the genocide?
Just because there's a call for a ceasefire now doesn't mean that the finding of genocide is going to go away based on evidence of the activities of the Israeli security forces. I think it's also totally unfair and wrong, morally and legally wrong, for them to issue sanctions against judges and prosecutors of the International Criminal Court.
Welcome to this episode of Expert Witness. My name is Sondos Asem. Today I'm joined by UN Commissioner Navi Pillay. She's a jurist whose career has shaped the very architecture of international justice, from breaking barriers as a lawyer in apartheid South Africa to serving as a judge at the International Criminal Tribunal for Rwanda and the International Criminal Court, to leading the UN's Human Rights Office. She has consistently pushed the boundaries of accountability for the gravest crimes. She currently chairs the UN Commission of Inquiry on the occupied Palestinian territory, which in its latest report concluded that Israel is committing genocide in Gaza. In our conversation today, we will explore how her earlier work on international crimes informed those findings of the UN report, and what her experience across courts and commissions tells us about the possibilities and limits of international justice today. Commissioner Pillay, it's a pleasure to have you with us today.
It's my pleasure too.
First, can you talk us through the key findings of the Commission of Inquiry report in terms of the acts of genocide and the specific intent of genocide that has led you to conclude that Israel has committed this crime?
I've always said when there is suspicion that a crime has been committed, where do the police begin? They begin by investigating the acts. And so we don't begin with the label. So we don't think, oh, why don't we name it genocide now? No. So it's the evidence that led us there. First, the commission analyzed the underlying acts of genocide as it is spelled out on the Genocide Convention. And the Commission found that 4 out of 5 of the underlying acts have been committed by the Israeli authorities and the Israeli security forces from 7th October 2023 to 31st July 2025. And these acts are killings of members of the group, causing physical or mental harm to the group, imposing conditions of life calculated to destroy the group, and prevention of births within the group. We did not find any evidence of the fourth underlying act in the convention, which is transfer of children from one group to another. So, having found that the underlying acts have been committed, we then analyzed whether the Israeli authorities had the specific intent to destroy the Palestinian group in Gaza through any of these 4 underlying acts. And we found that statements of Israeli leaders were direct evidence of genocidal intent. As for the evidence that we gathered, the Commission analyzed whether the only reasonable inference that can be drawn from the pattern of those activities by the Israeli security forces in Gaza, whether that is evidence of genocidal intent. Israel has consistently claimed that their military campaign in Gaza is conducted, one, in self defense, two, to defeat Hamas, and three, to secure the release of the Israeli hostages. So, as we assess the pattern of conduct of the Israeli authorities and the forces, we found that Israel's claims were not justified. There didn't appear to be any military objective in most of these acts. Firstly, the Commission found that the Israeli security forces have intentionally killed and seriously harmed an unprecedented number of Palestinians in Gaza since 7th October 2023 using heavy munitions. And second, the systematic and widespread attacks on religious, cultural, and educational sites throughout Gaza since 7th October 2023 were aimed at causing irreversible harm to Palestinians in Gaza by destroying elements of the Palestinian people's identity, erasing Palestinian culture from Gaza. And thirdly, Israel has had no intention to alleviate the suffering of the Palestinians who are trapped in Gaza and instead implemented a total and partial siege. On the contrary, and despite numerous warnings, including that these emanated from the International Court of Justice through its provisional measures orders that are binding on Israel, Israeli authorities have not only failed to facilitate the unimpeded access of humanitarian aid into Gaza, but they have continued the restriction or total blockade of humanitarian aid, including food and water, fuel and power, medical supplies and equipment, and other essential items and services from entering into Gaza, including food, water, and medicines. And fourth, the systematic and complete destruction of the healthcare system in Gaza, the siege induced deprivation of medical necessities to Palestinians, and the denial of medical exit visas for Palestinians to be able to get medical aid outside the country by preventing their capacity and possibility to heal, recover, and live. So, fifth, the widespread sexual and gender based violence is instrumentalized not only as punishment against the individuals, but as part of a pattern of conduct of collective punishment to fracture, humiliate, and subjugate the Palestinian population in its entirety. And six, the widespread and systematic targeting of children is part of a strategy to destroy the biological continuity and future existence of the Palestinian group in Gaza. Thus, part of the intent to destroy Palestinians in Gaza. The acts then fit in with the outcome of destruction of Palestinians. So, taking all this into consideration, the Commission found that genocidal intent was the only reasonable inference that could be drawn based on the pattern of conduct of the Israeli authorities. And so the Commission concluded that the Israeli authorities and Israeli security forces have the genocidal intent to destroy in whole or in part the Palestinians in the Gaza Strip. We found that the Israeli political and military leaders are agents of the state. Therefore, their acts are attributed to the state of Israel.
Commissioner Pillay, of these findings, what have been the most striking findings that stood out to you compared with previous cases you've dealt with? You were the president of the International Criminal Tribunal for Rwanda. You've investigated lots of shocking atrocities throughout your more than 60 years of legal career. So, what stood out in Gaza?
Yes, thank you for noting that I have experience in judging genocide and participated on the panel of judges who delivered the world's first judgment on genocide. Now, we should notice, of course, that all crimes are crimes. They must be prosecuted. What is different with the current genocidal campaign of Israel is that it is captured and displayed to the public live so that people on the streets and everywhere tell me all the time, yes, well, we can see what's happening. We are witnesses. This is an ongoing occupation and genocidal endeavor. And so that's key difference. It's ongoing and everybody's seeing in real time the killings and the destruction of these wonderful monuments and buildings and hospitals, schools, universities. And there has been no remorse at all for their conduct that have killed more than 65,000 Palestinians and more than 168,000 Palestinians injured. On the contrary, Israel continued with its genocidal campaign in Gaza despite warnings by the International Court of Justice, despite warnings and alarms raised by all credible organizations, and most recently, they attempted to discredit the report published by our commission, which is a UN commission. The Israelis continued to starve the population in Gaza and trap them in there, blocking all necessities from reaching the population, and they continue to target children. This is no longer war crimes or crimes against humanity, which is what we said on the 10th of October 2023. Now we look at the evidence and it's clearly genocidal. The Commission has received many testimonies from victims, expressed not only the injuries and harm they suffered, but collectively they show a clear pattern of their testimonies, as graphic and as heartbreaking as they are, also show that Palestinians are so resilient. Their resilience at times of a genocide is really admirable on the one hand, yet poignant on the other, because the international community have witnessed in real time the genocide that is unfolding and yet have done little to address it or to stop the carnage. It is really sad to say this, but the international community have failed the Palestinian people, and by this I mean the majority of states.
Commissioner, you've mentioned the standard of only reasonable inference as your way of concluding that genocidal intent was present in the Gaza case. You have explained that this is the same legal standard that is used and will be used by the ongoing case at the International Court of Justice in The Hague, the case that has been brought by South Africa, and that your report will remain the most authoritative finding from the United Nations to date until the ICJ delivers its judgment, probably in a in a couple of years from now. Concerning the methodology, could you highlight to our audience how your methodology is similar to that of the ICJ, and could your report help or be useful for the ICJ in its ongoing genocide case?
Well, the standard of proof in criminal courts, including at the International Criminal Court, is beyond a reasonable doubt, which we consider a very strict, stringent test, and which we applied in the ad hoc tribunals for Rwanda and former Yugoslavia. While the standard of proof at the International Court of Justice is fully conclusive, not as high as the criminal court standard. The standard of proof used by United Nations investigative bodies, like our Independent International Commission of Inquiry on the occupied Palestinian territory, including East Jerusalem and Israel, is reasonable grounds to believe, which is a less stringent standard compared to the International Criminal Court and the International Court of Justice. In order to prove specific intent to commit genocide through circumstantial evidence, the ICJ applies the test of the only reasonable inference standard. That is to say, intent to destroy the group in whole or in part must be the only reasonable inference which can be drawn from the pattern of conduct. So, in assessing specific intent to commit genocide in Gaza, through a pattern of conduct, we applied the test of only reasonable inference, similar to the standards of the ICJ. So, for the analysis of direct evidence of intent through statements, the Commission applies the fully conclusive standard when we examine the evidence. So these are more stringent standards than the necessary thresholds for a UN investigative body in general. Considering the nature of the crime, the Commission undertook to align its standard of proof for specific intent applied at the ICJ, which is the principal judicial organ of the UN. That's why we say we are the most authoritative investigation and conclusions as we stand until there is a decision by the International Court of Justice, because that is the highest court of the United Nations. Overall, we concluded on reasonable grounds that genocide has been committed, taking into account the most stringent standard applied for specific intent at the ICJ. Of course, I cannot comment on whether it serves as an indicator of the judgment at the ICJ, but the fact that the Commission applied a more strict standard shows that the conclusions we made are solid and the report as a whole is more authoritative.
Commissioner Pillay, you were the president and a judge at the International Criminal Tribunal for Rwanda, which was held between 1995 and 2003, and which delivered the first genocide judgments in the history of international criminal law. More specifically, you played a central role in the Akayesu case, which helped establish that rape and sexual violence constitute genocide or may constitute genocide. Can you first talk about this precedent in international criminal law and why it matters, and also how this case and how the debates around intent and evidence with respect to sexual violence as an act of genocide have shaped your approach to Gaza and to your Commission of Inquiry report?
In the Akayesu case and other cases where the ICTR ruled that rape and sexual violence constituted genocide, we relied solely on all the evidence given to us by victims. It's so important for us to hear from victims directly in order to come to a conclusion where we recognize that rape and sexual violence have a very far reaching and long lasting impact, not just on the individuals, but the community or the population as a whole. And of course, for genocide, it is important to find the genocidal intent, that perpetrators have the specific intent to destroy a group. It's a combination of those two intentions: intention to rape and sexually violate, and the intention to destroy the group, in that case, the Tutsi group. And this is what the chamber found in the Akayesu case. Rape was used as a tool of destruction to humiliate, to terrorize, and ultimately to destroy the spirit of the Tutsi people. The Commission finds a lot of similarities in the Akayesu case and what is currently unfolding in Gaza. It is important to understand the cultural and societal context. We found that the widespread sexual and gender based violence was instrumentalized not only as punishment against the individuals, but as part of a pattern of collective punishment to fracture, humiliate, and subjugate the Palestinian population in its entirety. And that's a significant, and why I like that you asked me this question, Santos, is because that's the first ever conviction where rape was considered a war crime, crimes against humanity, and even genocide. It was never prosecuted before, and many, many members of civil society and UN colleagues were working on begging the states to recognize rape as a war crime. I was recognized for having delivered the first judgment and writing that portion. So that is jurisprudence that we can apply clearly in the Gaza situation. We looked at videos where the Palestinian women were really humiliated, pictures taken by the Israeli soldiers holding up the underwear of Palestinian women were shown. Those soldiers were so proud of what they had done. They posted them on social media as with great pride. Um, so you have to ask, what is the military objective of raping women and men? How is that a matter of defense of Israel? So that's my response to that. That we would be doing the victims an injustice if we didn't look at the rape and sexual violence of women and men that occurred there.
Commissioner Pillay, concerning the reaction to your report, we've heard criticism and rejection of the findings of your report by Israel and the US, which was not a surprise, obviously. Have you received any threats or have you been the subject of any intimidation as a result of your work on this inquiry, either by Israel or by its allies?
I and my fellow commissioners were subjected to all kinds of abuse. In my case, nobody called me an anti Semite for the 6 years that I was UN High Commissioner for Human Rights and in my previous jobs as international judge. This kind of abuse started as soon as we accepted to serve on this commission of inquiry. I was called an anti Semite, and the commission is accused of being biased and selective, but we have a mandate, and we fulfill the mandate professionally and without bias. I'm very proud of the team that we have at the commission. The commissioners are supported by a small team. We have limited resources, and I'm truly want to tell the world how hard this team worked with utmost professionalism. I can say without a doubt that they will persevere to ensure the mandate of the Commission is fulfilled every single year. So, briefly, not subject to intimidation except through these abusive remarks, not only from the Israeli authorities, the ambassador, as well as the lobby groups supporting Israel.
Commissioner Pillay, we're talking today, a few days after the announcement by President Donald Trump of his plan for a Gaza ceasefire. It would be great to hear your view on this plan, the 20-point plan, which envisions Gaza becoming demilitarized and then governed by a transitional technocratic Palestinian committee with international oversight chaired by Trump himself until the Palestinian Authority is ready to govern. What's your take on this plan under international law? Is it consistent with international law? And more specifically, I would like to quote here Dr. Nimer Sultani, who is an outspoken Palestinian international legal scholar, who said, commenting on this plan, and now I'm quoting him, "The Trump-Netanyahu plan should be opposed and rejected. It offers Palestinians a choice between colonial apartheid and occupation at best, and gives a cover for the continuation of the genocide at worst. That's the end of his quote. Do you agree with this opinion? And does Trump's plan provide a pathway for ending the genocide? Or is it essentially a continuation of the genocide?
Well, I think that Mr. Sultani has very good reason and is justified in reaching that conclusion. Just because there's a call for a ceasefire now doesn't mean that the finding of genocide is going to go away based on the evidence of the activities of the Israeli security forces. Yesterday, I heard, or was it this morning, Trump once again said that if Gaza doesn't sign this his peace agreement, then he will support the total obliteration of Hamas. So if Hamas doesn't sign, this is what he will support: the total obliteration of Hamas. Now, this is not the way to enter a peace agreement by bullying and threatening on the one side. So that troubles me, and you have to distrust their motives. The main thing is that Palestinians are not part of this. They not only should be part, they should be the controlling feature because they are able to govern themselves. The conclusions of the commission still stands. Israel has committed genocide and is continuing to do so. Whether or not the Trump Netanyahu plan will help stop the genocide, it's highly likely to me. In relation to the plan, I need to stress that this plan must take into account the responsibilities of all parties. And as I said, it must involve the Palestinian people. There is no other way, and there should not be another way. I also want to stress that the plan envisions an interim administration rather than allowing the local political actors to take immediate control. This undermines local legitimacy. The plan allows Israel to maintain significant security control over Gaza, and this would restrict Gaza's independence and ultimately the sovereignty of the Palestinian people. And this plan goes directly against the declaration of the International Court of Justice, which gave a deadline which has just expired, that the occupation must end. Peace plan doesn't address that at all.
Commissioner, despite the finding of your report that genocide is definitely being committed and has been committed in Gaza, the United Kingdom, where I'm based at the moment, consistently refuses to label what's happening in Gaza or Israel's conduct as a genocide, and they basically adopt the view that a determination should be decided by a court, in this case, of course, the International Court of Justice, which is hearing the case. However, we all know that the decision or the judgment by the International Court of Justice will take a couple of years. Perhaps we are expecting to hear this decision by the end of 2027 or the beginning of 2028. What's your take on the UK's position? In your opinion, is the UK's policy in this regard sound, or is it unfounded? And what's the UK's legal obligation now? Should it adopt the findings of your report and call it a genocide?
First of all, the international community need not wait for a report from a UN body such as our commission, nor do they need to wait for a ruling on genocide by an international court such as the International Court of Justice. Why do I say this? Because there is a legal obligation in the Genocide Convention on the part of every state whether the genocide has occurred in their territory or not. So the UK then is under a legal obligation to prevent genocide, to punish the commission of genocide. So, how are they going to do that if they don't heed the indicators of genocide? The court in its provisional order granted at the request of the South African legal team, said that there are plausible indicators that genocide is happening or may happen. So that's one indicator. The other indicator to the UN government should be our report, which sets out facts, and they can make their own decision on based on this report, which gives the statements of incitement made by the political leaders in Israel, as well as what is happening in front of their eyes. The killing of thousands, 62,000 people, women, children, and denial of medical care, food, humanitarian aid. These are all evidence on the ground that the UK is waiting for, and they are obliged to fulfill the order of the ICJ that all states must take action and that Israel must end the occupation, and they were put on a deadline. Um, So, as I said, there is a duty under international law to punish and prevent genocide, and this duty was triggered at least since January 2024, when through the Provisional Measures Order, the ICJ confirmed that this obligation by every state comes into effect. The Commissioner's report, as I said, is the authoritative report from a UN body to date. The Commission applied the same stringent standard laid down by the ICJ regarding the genocidal intent element. Therefore, our report should be referred to by the international community as a strong indicator that they must act now to stop the ongoing genocide in the Gaza Strip. And we have provided some concrete recommendations to states, and these recommendations provided some concrete directions to states, and they must be taken seriously and implemented as far as possible. Now, I can give you an idea of the recommendations to states if you wish.
Please go
All
ahead.
right, so I'll go ahead. We recommend that states, one, should employ all means necessary and reasonably available to them to prevent the commission of genocide in the Gaza Strip. Secondly, we recommend that states cease the transfer of arms and other equipment or items, including jet fuel, to the State of Israel or third states where there is reason to suspect their use in military operations that have involved or could involve the commission of genocide. And thirdly, to ensure individuals and corporations in their territories and within their jurisdiction have not involved in the commission of genocide, aiding and assessing the commission of genocide, or incitement to commit genocide. And states should investigate and prosecute those who may be implicated in these crimes under international law. Next, to facilitate the investigations and domestic proceedings that have taken place or take place, including imposing sanctions against the State of Israel and against individuals or corporations that are involved in or are facilitating the commission of genocide, to commit genocide. And finally, to cooperate with the investigations of the Office of the Prosecutor of the International Criminal Court. And so these recommendations that we made are and should be addressed immediately by the UK government.
So, does the UK government now risk being complicit in genocide if the supply of F 35 parts continues, in your view, given these recommendations of your report?
Based on the evidence that we found, there is complicity on the part of states who are supplying weaponry, fuel, and other kinds of report. And there are other laws and treaties as well, such as the Arms Treaty, which directs that states do not supply arms to states that are likely to use the weapons they have provided to take sides in a conflict. So there are the Genocide Convention and other laws that the UK is party to. Doing continuing with these activities could well expose them to a count of complicity in genocide.
Commissioner Pillay, you were one of the first judges to serve at the International Criminal Court. You served as an appeals judge between 2003 and 2008. I wonder what you make of the current sanctions facing the court, imposed by the administration of President Donald Trump. Of course, the Trump administration has sanctioned the chief prosecutor, his deputy prosecutors, a number of judges, and also people who have cooperated with the court or people who supported the work of the court, such as the UN's Special Rapporteur on Palestine, Francesca Albanese, and even Palestinian human rights organizations like the Palestine Center for Human Rights and other NGOs. What do you make of these sanctions, and do you support calls to bring a case at the ICJ to defend the diplomatic immunity of UN rapporteurs after what Special Rapporteur Francesca Albanese has been subjected to?
I strongly am against these sanctions. I see it as a direct and intentional interference of the judicial system and the obstruction of the rule of law. So I would urge all member states to strongly challenge these sanctions in every way possible, including by getting an opinion from the ICJ on the weight of the Privileges and Immunity Act that all people working within the UN come and should receive the benefit of those privileges and immunities agreement. I think it's also totally unfair and wrong, morally and legally wrong, for them to issue sanctions against judges and prosecutors of the International Criminal Court. I know these judges and prosecutors, deputy prosecutors. They have a huge job to do. And the United Kingdom is very happily cooperating with these judges and prosecutors in the matter of the complaint against Russia in respect of the Ukraine attack. So they can't be selective and support one cause is because the UK is a member of the Rome Statute, supports the referral of the Ukraine situation, and yet does nothing about the penalties imposed by the US against these judges who are carrying out their mandated job. And the one on Francesca Albanese is almost cruel. You know, I met her just before I left Geneva. That's why I say they're immoral and they're wicked, these sanctions, to go and target individuals. In this case, Francesca Albanese, who was rendered such service out of commitment and without any remuneration, showing she doesn't have any personal agendas in carrying out her important mandate. I hope that these sanctions against these individuals will be lifted as soon as possible, if not immediately.
Commissioner Pillay, looking back across your extraordinary career, I'd like to hear your reflection on the slow pace of international justice. I'm sure you've seen how long cases at international courts may take. What's your message to those who see international justice as too slow or ineffective, even in the face of today's atrocities?
Firstly, even in national courts, where they have a single accused and maybe one or two witnesses, they sometimes take court. I once had a note of how long some of these cases have taken especially the trials under the Terrorism Act in the US and many other countries. They do take long, but here in the international court, they have to listen to thousands of, I mean, hundreds of witnesses and thousands of documents. The judges are very concerned about how long it's taking, but this is the way the 21st century trials occur. Everybody in the ICC, they even give the victims the right to a counsel and to address the court and participate in the proceedings. We've come a long way from the Nuremberg tribunals, which were all decided on affidavits and paper witnesses. So they finished their trials, quite a few of their trials, within 10 months. So 21st century rules on fair trial protects everyone. And we've come to this with some satisfaction that you can trust today's proceedings, even though it takes long. And it's important for everyone to remember that we want justice to prevail, and we shouldn't take up the negative position that the trials are taking long to abandon these trials. Now, in my personal experience under apartheid, all of us people of color had nowhere to turn to where the laws were so immoral. Racism was institutionalized. We couldn't turn to anyone. And so many people, and obviously including the late President Nelson Mandela, were thrown into prison for life. And he served 27 years, as you know. So we didn't have a, a tribunal to turn to for fair trial. We were stuck with the apartheid courts where we received no justice. And so I always longed for a system of justice. And that's why I was very interested in the Nuremberg trials. I was 18 or 19 or so at university when I read these Nuremberg case reports. And that's what I anchored for. Not only in my country, many other countries in the world, including Africa, have no other system to turn to. And that's why my dedication and belief in an international justice system based on the norms and values set out by the United Nations when they passed the Universal Declaration of Human Rights.
Your legal career is quite inspirational, and I'm sure you're a role model for many young legal students or aspiring lawyers and judges. So I wanted you to give us some highlights from your more than 60 years journey in international justice. What are the highlights for you? You served as the president of the International Criminal Tribunal for Rwanda, which delivered the first genocide judgments in history, and then you were one of the founding judges of the International Criminal Court, where you were an appeals judge from 2003, and then you were the United Nations High Commissioner for Human Rights, and then an ad hoc judge at the International Court of Justice. Which one has been your favorite role, and what is more effective in your from your perspective, the legal roles, or your when you served as a judge, or as a High Commissioner for Human Rights?
So, as I said, I started very young, but in South Africa, very many people of color were poor and couldn't afford a university education. The poor community of Clarewood, a suburb outside Durban, raised funds to send me to university. So I'm truly grateful to the community support. They were told by my teachers, we have a young girl who has the potential to do something in life. So those were my small beginnings. Um, I had to serve articles in order to become a lawyer. You have to serve for 2 years as an intern. And that's where I learned as I went into the rural areas, the suffering of Black people and how cruel the apartheid system was over them. And all my lessons were learnt from the people who struggled for liberation in South Africa and from women. Women would come to me and tell me about the domestic violence against them, and they would cry and weep. And at first, I was very impatient with them, thinking, why are they crying? They should just be strong and hit him back or move out of the house. Well, it's not so easy as you listen to them. That's my first lesson. I addressed the issue of domestic violence or gender-based violence, and I went to see the chief magistrate and asked him to use the apartheid era. This is a 1953 apartheid era law, which I think was there to protect the white people against what they call nuisance from Black people who were whistling on the street or talking loudly. And so I persuaded the chief magistrate to get all the magistrates to grant peace orders for the protection of women from the bachelors. It was usually a domestic situation. And that's where I learned to always look for an opportunity to bring out an issue and deal with it because the community is suffering out there. They know what it is to suffer, and they don't have the power, say, that I had as a lawyer to defend people in court. And I represented most of the opponents of apartheid who belonged to various opposition groups such as the African National Congress, the Unity Movement, the Black Consciousness Movement. And really, I was running a human rights office because most of these people can't pay you for their services. But I'm pleased that I did that. I also went on to study and got two postgraduate degrees from Harvard in my master's and the doctorate. And my fellow lawyers in Durban said, "Well, how is that going to help you? It's not like you can charge more fees than us." And I said, "Well, you spent your money buying a Mercedes Benz car. I'm spending my money to study further so that I could be a better lawyer in the courtroom and do the best for the client." It looked hopeless, but in apartheid South Africa, we did win some very important rulings. For instance, my husband was detained, and I brought an application under the Terrorism Act. I couldn't ask for his release because the power of the courts to do that was removed under this act. Really, what I wanted was to have him released. I didn't get that, but we got an order where the judge ordered the security police not to use unlawful methods of treatment of detainees and ordered the sheriff to serve that order on him. And when he was eventually released, he told me how much that order meant to him, that he had burst out crying when he received it. And the other is after my clients were all convicted and sent to Robben Island prison, and I went to see him about their case. You can't talk about prison conditions, but we used methods of communication. And they told me one of my clients, who was a lawyer, was uh, sent into isolation with spare diet because all he did was he presented a petition to the officer commanding Robben Island prison because they didn't know what's their rights. They didn't have the prison rules and regulations. And they didn't have a right to a lawyer. They didn't have a right to study. They didn't know what their rights were. But Mandela had told them to tell me not to bring an application because you can't win a case in the apartheid court. I was very young, I was in my 30s. I went and consulted various senior lawyers of whatever race they were. They all helped me with ideas and encouraged me to do the application. So, just to cut a long story short, we won the order for them, and finally they had prison regulations, and they had a right to a lawyer and right to study. And these were very, very important for them to survive in prison. So I'm making the point that you can make a difference if you try in whatever capacity and power you have.
Absolutely. And as far as I understand, you've also had an instrumental role in the torture convention.
Well, I mentioned the application I did for my husband when he was in detention. I supported that application with his own written note because he was let out for a period and then locked up again. And in that time when he was out, he left a power of attorney in my favor, and he left a written note about how they treated him in the earlier detention. So there was my affidavit setting that out, and 10 affidavits from my clients who had been detained together with my husband. My husband was not charged, but they were. And they were horrendously tortured. And we made sure that those affidavits reached the anti apartheid group that had observer status in the United Nations. And for the very first time, that the UN then had sworn affidavits that torture was being practiced in apartheid South Africa. South Africa's supporters asked for a convention to prevent torture because there was no such convention up to that time. They also asked for sanctions against South Africa from the United Nations. That was vetoed by the United States and the UK government, Margaret Thatcher. Later, we all realized then they were going against the United Nations and supporting racism, institutionalized racism. But that's what happened. And then after Stephen Biko was killed shortly after these affidavits reached the UN, they helped to move for a convention against torture and something that now benefits people who are at risk of torture all over the world. So I started with a small goal and never realized the full implications of these, and always to secure rights and protection for people.
Thank you, Commissioner Pillay, for your time today. I appreciate you joining us despite your very busy schedule.
Thank you very much. Thank you for your questions.